We're gonna go ahead. All right, Facebook, we are back. YouTube and Instagram, thank you for your patience. I am so sorry about that. I don't know what happened. It just conked out on me. It's cool. All right. So we were about to get started on our stories. So that is what we're going to do, my friends. Like I said, every week I talk about pop culture stories and we discuss the legal issues that they have to do with. So the first story this week that we are talking about, if you have heard of or watched Lord of the Rings, you'll be interested in this, okay? So this is the case. It was, okay. I'm doing it through my phone. So we'll see if it works on my phone. All right. So our first case is the Hobbit Hill trademark lawsuit. So here's what happened. There was a couple called, their last name is the Wheatons, and they opened a farm last April and named it the Hobbit Hill Homestead. Now, if any of you are familiar with Lord of the Rings or the author of the books Lord of the Rings, because the movies are based on books, J.R.R. Tolkien also had a book called The Hobbit, and they are a race of people, right? So when the wife named the farm Hobbit Hill Homestead, she said that she thought a hobbit was a small woodland creature with giant hairy feet and was a fun-loving type that liked to smoke a little pipe, like a gnome or a leprechaun, all right? So she thought a hobbit was just a common word and it's just, you know, a creature out there, mythical or not, like a unicorn. Unfortunately, Middle-earth Enterprises, they own the worldwide rights to all of the terms in Tolkien's fantasy world. So if you think about Lord of the Rings, like the language, the orcs, the hobbits, whatever is in that universe of Lord of the Rings, Middle-earth Enterprises owns the rights to those characters, those words, okay? So they sent the Wheatons a cease and desist letter. And Middle-earth Enterprises said, "We're happy that you love The Hobbit or name your dog Frodo, but once you start making commercial use of it, we have an obligation to protect our mark." The Wheatons agreed to change the name, but they said that it's been difficult because they've been marketing for over a year as Hobbit Hill Homestead. So I picked this case for several reasons. Because one, you have, I talk to you guys a lot about things becoming generic. So to this woman, Hobbit was so popular, it was so regular, she had no idea that it was owned by a company. And this is what can happen if you don't protect your stuff ahead of time. I talk to you guys all the time. I told you, Baby from Cash Money, the song Bling Bling. He said, had he not known that the song Bling Bling was going to be, had he known the song was going to be such a big hit, he would have trademarked the word bling. And now he can't because it's generic. Middle-earth Enterprises, however, was smart, and they trademarked everything in the Lord of the Rings and the Hobbit universe. So whenever you use it, they're like, hey, that's ours, okay? Also, some fun facts that I want you guys to know about this case. Did you guys know that gnome is actually a trademarked word, and it is owned by the Gnome Corporation? And also, the leprechaun and shamrock are trademark are owned by Notre Dame University, which, by the way, was my college rival, BC Eagles. Thanks. Okay. So they, the Wheatons, in response to this, they have agreed to change the name. They're changing it to Wheaton Mountain Farm. They did their research on the USPTO website to make sure that the name wasn't taken, and they're good, okay? So that is case number one. Case number two, I actually talked to you guys about it, maybe, I think last Friday, because I found it last Friday. Beyonce is being sued. They trying to get my girl. So I talked to you guys about it on Friday. Beyonce was, and Jay-Z in 2017 applied for a trademark for Blue Ivy Carter, their first daughter's name. When they filed it, the application was opposed by a Boston wedding planner whose company just so happened to be named Blue Ivy. Her company was started 3 years before Blue Ivy was even born. So she opposed the trademark application, all right? And then she went, she got in touch with, you know, the Carter's people, had some meetings. She offered them to buy her company and the trademark for $10 million and some collaboration projects, and they said no. So now she is asking them to compel Beyonce, Queen of Privacy, to turn over text messages between her and Jay-Z and her mom to prove that she had planned to trademark Blue Ivy's name before the wedding planner trademarked it. Okay, so first of all, we all know Beyonce is not going to hand over those text messages. Second, it's probably unlikely that Beyonce and Jay-Z had planned to trademark their child's name before they even knew that they were going to have a child. Okay. Third, Beyonce is not in the wedding industry, so other than the names being similar, no one really associates Beyonce with weddings. So I'm not sure why she thought that Beyonce trademarking her child's name would prevent her wedding industry from thriving. On the other side, the problem with this is that Jay-Z is quoted in a Vanity Fair article, I believe, saying that he would trademark his children's names to keep other people from making money off of them. And you cannot do that. Trademarks are not here to prevent people from making money. They're here to help people make money. So if you have a trademark, you must be using it. You can't buy a trademark just to sit on it. You have to get a trademark and use it to make money. All right. So this case is still ongoing. I'm pretty sure Beyonce and Jay-Z have locked down Rumi and Sir Carter's names already to prevent this from happening, but we're going to keep our eye on it. Okay. Next case that we are talking about is something that I am very familiar with. How many of you guys know about a little website called LegalZoom? Well, LegalZoom is being sued by a law firm that is called LegalForce, okay? So LegalForce is claiming that LegalZoom is infringing on their trademark. LegalForce has a search engine called Trademarkia that lets you search trademarks, kind of like the USPTO website that lets you search trademarks, right? LegalZoom offers a similar service, and allegedly they bought a domain called LegalZoomTrademarkia.com. Okay, now this whole case is part of a larger antitrust case by LegalForce against these websites that provide legal services, because he's saying that they are practicing law without a license. So LegalZoom has actually stopped using the Trademarkia thing, but we're gonna see what happens with LegalForce, because apparently he's suing all these people out here. All right. Next, we're going to take a little break and remind you guys that you are watching NPL Legal Dish. Hi, New Haitian. You're watching NPL Legal Dish with Natalie Pierre-Lewis, your business formation boss. I am here to help you with all your business formation needs. If you need contracts, trademarks, setting up your business with the state, hiring employees, I'm your girl. Right now, I'm having a discount sale on my Protect Your Biz replay bundle. Last night I had a webinar where I taught the basics of trademarks, copyrights, and patents. You can get that webinar plus my 3 intellectual property ebooks for just $35 until 10 a.m. tomorrow morning. After that, the price goes up to $79. So I would suggest y'all hop on it tonight. All right. But yeah, go get the replay bundle because it's good stuff in there. It's 2 hours of instruction and 3 ebooks. So now we're going to get back to our show. Hello, One True Empress. How are you? Next case we are talking about today is Landstar System versus American Landstar Logistics. Okay. So here's what happened. Landstar Systems sued American Landstar Logistics for trademark infringement, and they won. So we don't even have to go through the facts of the case because Landmark won. What happened, what's interesting is what happened after. So after they won the suit, they asked for records from American Landstar Logistics so they could determine damages, right? Their initial award was for $375,000. However, the defendant started acting funny, said they didn't have the records, they said they were going out of business, and just refused to hand over any of the information. So the court increased the damages to $6 million. So when I tell you that trademarks are valuable, I'm serious. This is a case of treble damages where because of your negligence, because of your infringement, and because you basically disrespected the law, they can up your penalty. All right. So it's really important that you have your intellectual property in line. Okay. Next case that we are talking about, it is a really important case for all of you who want to sell your crafts online, particularly if you're trying to open an Amazon store. Amazon is basically cracking down on counterfeits. So pretty much if you want to sell on Amazon going forward, you're going to need some type of trademark for your wares. So here is what's happening. Amazon has this program called Project Zero. It is software that is going to be on the Amazon website that is going to check for knockoffs. If you are a brand that is trying to sell on Amazon, you're going to have to submit trademarks, logos, all that stuff to show that you're legit. This software is going to make it so that brands no longer have to go through Amazon to get fakes of their stuff taken down. It's kind of a self-service process, okay? Each of your products is given a unique code on the Amazon system. The reason why they're implementing this program is because Amazon has a big problem with counterfeit merchandise. They actually lost out on a deal with Swatch because counterfeiting is so rampant on Amazon, and it's estimated that 13% of the products on Amazon are fake. And it's a real problem because Amazon would like to sell luxury brands, but they can't get them to do it because the brands are afraid that people are going to sell knockoffs. That's why you don't see a lot of Nike or, you know, Louis Vuitton or Burberry on Amazon, because those brands do not want to partner with Amazon because they don't want people stealing their stuff or doing counterfeit merchandise. Okay. So if you're planning on selling on Amazon, get your trademarks in order. Okay. Next is a very quick one. I've had a couple of stories that I've done about Monster Energy drink. They like to sue people a lot, and they've lost another case. So this time they were trying to, they basically are trying to go after anybody who uses an M in their trademark. And the court is like, no, especially if it's not in your industry, unless it is in your, Monster is going after like power tools. They're going after like food. They're going after clothing companies. Unless it's in your industry, it's not infringement. Your trademark only covers you in your industry. So if your trademark is in hair and somebody uses the same mark for, I don't know, selling power tools, there's not necessarily any infringement. Once your Empress, what are you saying no to? While you do that, I'm going to start on this next case. And this is another one about trademark infringement of Louis Vuitton versus My Other Bag, okay? So, everybody knows who Louis Vuitton is. No M? Yeah, you can't just trademark a letter. They're trying to go after everybody who has an M. All right, so on to Louis Vuitton. So everybody knows who Louis Vuitton is. There is another company called My Other Bag that does cartoon depictions of Louis Vuitton bags. So it'll be like shapes and stuff, and it'll kind of look like a Louis, but it won't have the LV. It'll be in crazy colors, and it's very obviously a fake. Okay. Louis Vuitton sued My Other Bag, saying that it's a dilution of the Louis Vuitton luxury brand. The court said that there was no confusion because it was a parody, meaning they're not trying to act like they are Louis Vuitton. They know that it's a fake, and they're telling people that it's fake. So there's no problem, okay? So Louis Vuitton lost, and they were supposed to pay My Other Bag's legal fees, which was somewhere between $424,000 and $803,000, okay? My Other Bag then also, countersued and said that Louis Vuitton is a bully and they wanted damages for that, and they're a small brand. Louis Vuitton said that they were just so they sued Louis Vuitton because they wanted court costs and said that Louis Vuitton is a bully. Louis Vuitton said they were just protecting their brand, and the court agreed, so they said that My Other Bag couldn't get any court costs. Okay? All right. So that is, I think My Other Bag in that case, they kind of pushed their luck. They should have, yeah. Like, I don't know how I feel about this case, because when you look at the bags, it's obvious that there is some kind of reference to Louis Vuitton. So I would encourage you to go look up My Other Bag and compare it to Louis Vuitton bags and see what their designs are. It's very obvious that there's some correlation, but there is nowhere do they say, oh, this is, Louis Vuitton like. They're very open about the fact that this is not a luxury brand. So, you win some, you lose some. Next case we're talking about, if I have any BB lovers in the audience, I remember BB in the mall. I could never fit their clothes because they were very tiny. This is very trendy clothes, but BB stores closed a while ago. However, BB is suing for trademark infringement against this company called Centric Brands, okay? So BB and Centric Brands, they had an agreement where Centric Brands had license to make, market, and sell clothing with the BB name. When BB went out of business, Centric Brands had license to sell whatever merchandise they had left, but only online through authorized key e-commerce sites, okay? Specific sites, and it was for a specified period of time. So basically, BB was like, we're going out of business. You can sell whatever you have left, and, whatever's left after that, if you have something extra, you can sell it on these specific sites, all right? They were not allowed to sell to discounted retailers. However, BB found out that what Centric Brands did was sell the merchandise to a third party who would then sell it to these discounted sellers. So you had it in places like Marshall's and TJ Maxx and Ross and all those places, which was against the agreement, okay? BB sued and said that it dilutes their brand, and they want $2 million per mark per type of goods sold. So basically, for every dress, jacket, or purse that Centric Brands sold with the BB brand, BB wants $2 million. What do y'all think? Do you think it's too much? Do you think that it's reasonable? In the meantime, while this is happening, BB allegedly says that they're planning to revamp and open up their own e-commerce site. Okay? Money, money, money. You think they should get the money? Okay. All right. Okay. All right. Next case we are talking about has to do with a fitness company that I think everybody, well, not everybody. If you have ever heard of Peloton, Peloton is a very famous biking fitness company. They sell bikes that run for about $2,200, and they have a video subscription where, you can bike with like a video of different scenery. The video subscription is $39 a month. Okay, they're actually bigger than SoulCycle, which is very popular. Now, they have just been hit with a $150 million lawsuit for copyright infringement, because in this video subscription, they synchronize a lot of popular songs, like from Drake, Rihanna, just a lot of, popular singers to their scenery videos. But they don't have licenses for any of them. Mind you, they have over 1,000 songs that they use in their videos. Peloton is worth $4 billion. How did you not get copyright licensing for 1,000 songs? So they're going to have to pay out the nose. We'll see what happens. Okay? But if you've ever ridden a Peloton bike, they need some coin. Shoot. All right. Quick break. If you just popped in, I'm Natalie, Napster 2019. Yes, Napster 20. Yes, Napster 2019, definitely. All right. Next thing we're about to talk about Taylor Swift, but before we do that, I want to remind you guys that my Protect Your Biz webinar is discounted for tonight only until 10 a.m. tomorrow Eastern Time. $35. After that, it goes up to $79. This is a 2-hour training on trademarks, patents, and copyrights, plus the 3 books in my intellectual property series on patents, copyrights, and trademarks. So I suggest you get it for $35 before it goes up to $79, okay? All right. So let's get back to our story. This is a case of Taylor Swift versus the Swift life. I'm not a big fan of Taylor Swift. I think she's kind of mean, but pretends to be like a nice girl. Anyway, Swift Life was a computer company, and in 2008 they had a trademark for Swift Life. Okay. 2017, Taylor Swift came out with an app called Swift Space Life. Now, the computer guy, his Swift Life was one word, okay? The computer guy found out, and he sued Taylor Swift. Okay. And he sued Taylor Swift for trademark infringement, okay? He said that when they launched their app, it made his, so when you Google something and the things that come up first, that is, you can pay for that, okay? He said that after the Swift Life app came up, his Google search rating came way down. He was like way at the bottom. He said that people were emailing him about the Taylor Swift and the Taylor Swift app. So he sued for trademark infringement and confusion, okay? Taylor Swift said that he sued, or her legal team, I should say. Hi, BE3071. They said that he sued in the wrong venue, that he was a one-man computer company, and that his trademark doesn't cover the app, it just covers repair services, okay? But her people still ended up shutting the app down, okay? But now they're countersuing, and they're saying that he got the trademark by lying to the USPTO office. Because the reason that they said he lied is because his trademark is for Swift Life, but he was marketing his company as S.L. Swift Life Computer Services. Her people were just being nitpicky, okay? So they want his trademark canceled, and they want him to pay the Taylor Swift legal bills. Are you kidding me? Meanwhile, the computer guy is like, he wants the countersuit dropped because he's like, there's no trademark infringement. It's his, it's in his name. He never intended to use it as one single word. So we'll see what happens. I'm hoping that they drop the countersuit, because the basic argument of Taylor Swift's legal team is that he's just a little company and they're bigger. Are you kidding me? Yes, give it up, Taylor. Give it up. All right. Next case we're making good time, guys. Next case we're talking about, so if any of you watched American Horror Story Coven, there was a scene where one of the characters, she had red hair and she dressed very eccentrically. So it was a season about witches, and this witch gets burned at the stake. And as she's getting burned at the stake, she screams, "Balenciaga!" And Balenciaga is a very famous luxury brand, okay? So our next case has to do with Balenciaga versus a very famous company, but that isn't as expensive, the Car Freshener Corp. And the reason why they're very famous is if you have ever seen a Christmas tree in somebody's car, it's owned by Car Freshener Corp, okay? So here's what happened. Balenciaga basically took the car freshener shape and made $275 keychains. It had the tree, it had the name, it had and then on the tree it said Balenciaga, and then the year. Car Freshener Corp sued because they have a trade dress trademark. So the way that the tree is shaped, they have a trademark on it, okay? Plus, they have had 66 years of continuous use of this shape, and it is a staple of American culture. Because if you think about it, when you see that little tree, you know it's an air freshener. Everybody knows what that little tree is, and everybody has their favorite scent. My friend, whenever I get in her car, she loves black ice. I don't know why, because it reminds me of my uncle, but she loves black ice. But everybody has their car freshener scent that they like, their little tree, right? Balenciaga said, well, the shape is functional, so you can't trademark it. Okay? They said that the shape is functional, and what they did was they brought up a utility patent that they had in 1962. Now, if you were in my webinar yesterday, you know that we talked about patents and that utility patents are good for 20 years. So if the utility patent was filed in 1962, it would have expired in 1982. And they're saying that the fact that they had a patent means that they could not trademark the shape. However, I don't know, the court didn't even get a chance to decide on the case because they settled. And when I read the article, the person who wrote it, they probably came to a licensing agreement, and probably going to have to, Balenciaga probably offered to pay some of the profits out. So don't be surprised if you see collaborations between Car Freshener Corp and Balenciaga in the coming days, if you want a $275 keychain. Can you imagine having a car Christmas tree, the air freshener, on your keychain for $275? You must got me messed up. People like to waste money. But yeah, that's their business. All right. Next case we're talking about has to do with something called the ARC bag, okay? And it is a case between a company called Cult Gaia, which is owned by the son of the CEO of MGA, which owns Bratz. So if you remember when I was talking about the cases last week, we had a whole case about Bratz and the owner, the MGA company. Well, the one of the people who run MGA, his son owns this company called Cult Gaia. And they came up with this bag called the ARC bag. It was a bamboo bag with a specific shape. It kind of looked like a fan. Very cute bag. Go look it up, the Cult Gaia ARC bag. Steve Madden came out with their own ARC bag. They didn't call it the ARC bag, but it looked just like it, right? Cult Gaia sent a cease and desist letter because they said they had trade dress rights, meaning that the way that the bag was shaped was very functional, and Steve Madden can't just steal it. And Steve Madden's like, girl, it's a purse. We can copy it. Okay, so now when they filed this cease and desist against Steve Madden, their application was still under review by the USPTO office. So they had filed for the trademark, but they hadn't gotten the official approval yet. So remember, when I said, when you start filing, you can still, you can still exercise your rights as a trademark owner while your trademark is being reviewed. That doesn't prevent you from doing that, okay? So their application was still under review by the USPTO. They made about $4.5 million in sales on that bag alone. They said that people have come to associate that bag with their company. The only problem is that this bag is based on a vintage Japanese bag. And if you do some research on it, it looks practically identical. And the attorney who was reviewing their application in the USPTO wasn't sure that he was going to approve it because he thinks that it's just an appropriation of an already existing bag, okay? However, the plot thickens because a Chinese inventor, so China comes in out of nowhere, and a Chinese inventor named Min Ling Lin got a patent for an ornamental design of bamboo. And the bag looked exactly like this ARC bag, the Cult Gaia bag. I wish I could show it to you, but I'm broadcasting on my phone and on my computer, so I can't. But look up the ARC bag, okay? So the patent for this bamboo bag, it looked just like the ARC bag, okay? Now remember, design patents last for 15 years, okay? Legal experts are saying that even though this person has come and they've gotten a patent on the bag, that's not going to stop the trademark. And I think that is what's interesting, because trade dress doesn't, in terms of how something looks, it doesn't have to be unique, right? And that is what is it? Cult Gaia is saying. They're saying that we have a trade dress trademark. The way that our thing looks is our thing. This Chinese inventor, there's when you have a patent, your patent has to be unique. It has to do something new, okay? So they're saying that this patent does not affect the trade dress. And actually, it would be better if the Chinese inventor Lin did not sue, because Lin's patent could be invalidated, because they could say, well, this patent that you got for the bamboo bag is not new. This is just revamping an old model. So he would probably just better stay quiet, and we're going to see what happens with the ARC bag, okay? All right. I got about 15 more minutes, well, 15, 20 more minutes. Next case is very quick. If any of you guys watched the Fire Festival and you know that Jerry Media was one of the people involved with the Fire Festival, they're being sued again for stealing a meme. They're being sued because they stole a meme to promote someone else's vodka. These people will not stop. They are determined to steal the whole world, y'all. Watch out for Jerry Media. They're probably stealing your tweets too. Hi guys, Dallas wants to say hi. All right, but next story we are talking about, Weinstein Company. If you guys have been paying any attention to the news, you know that Harvey Weinstein has been a big name. He's been accused of a lot of sexual harassment of women in Hollywood. He had to resign from a lot of things. Well, his company is being sued over using a trademarked line in a Bill Murray film. There was a movie in 2014 called St. Vincent. And in that movie, they used a line, Bill Murray's character used a line, said, "And down the stretch they come," right? This phrase is the trademark phrase of a horse racing announcer, okay? He's used it in many Triple Crown broadcasts on ABC. And he registered it in 2012 because he saw other people, he heard other people using it on different, media outlets, and he wanted to preserve it. And he was very inspired by Michael Buffer, who's the guy that goes, "Let's get ready to rumble." If you didn't know, that phrase is trademarked. And if you want him to come say it at your event, it costs money. I ran into someone who hired him for an event, and they said basically we had money to get him there, but we didn't have money to get him to say the phrase. So your trademark is money, okay? So he registered his trademark. His lawsuit against the Weinstein Company is that Bill Murray's character in the movie was unsavory, he wasn't likable, and he's saying that it tarnishes his brand as an upstanding horse racing announcer, okay? On top of this, the Weinstein Company declared bankruptcy last year, so we'll see if he wins, and if he can even get any money, all right? All right, we've only got 2 more stories. quick commercial break. Hi guys, I'm Natalie Pierre-Lewis, Business Formation Boss. I help you get your business off the ground legally. Go get my Protect Your Biz webinar for $35 tonight only. It gives you the basics of trademarks, patents, and copyright so that you can protect your business ideas from being stolen and keep you from being sued. It goes up to $79 tomorrow morning, so get it tonight, all right? Now, if any of you watching are parents, you know about, of young children, I should say, you know about Peppa Pig. Well, Peppa Pig, she got some juice because Peppa Pig got a trademark invalidated. All right. So Peppa Pig, or Peppa Pig's creators, sued this man named Xian Hao Pan. Mr. Pan applied for a trademark for, it was a picture of a hooved animal that's called a tapir or a tapir. It's spelled T-A-P-I-R. The head of the tapir on a human body and the word Tobia, T-O-B-B-I-A, in bold black text under the colors. And the colors that he used for his whole logo design were red, blue, yellow, and pink. Okay, and the trademark was for clothing, footwear, and headgear. However, Peppa Pig's creators said it would be confusing because they have an earlier version of a Peppa Pig trademark that is in black and white for the same type of goods. Now, Peppa Pig's trademark was black and white. Mr. Pan's trademark is color, but the court said there is enough similarity between these two marks that people think that they're going to be affiliated. And Peppa Pig shut Mr. Pan down. So just because you add different colors, if the shape is the same, you know, you really have to make your trademark distinctive. It's not that hard. Maybe he could have done the head of a fox. Maybe he could have done the head of, you know, something else, but not something that looks so much like Peppa Pig. And this is what happens when you have these knockoff brands. Sometimes you look at it and the logo looks just like the original one, right? Okay. So, we are down to our last case, guys, and then I'm going to run out because I have a client meeting at 7 o'clock. Your girl's always working. You know how I love my wrestling stories. Well, today we have another wrestling story of the WWE versus Tatevik Hunanian. Okay? I don't know how to pronounce the name. Anyway, so here's what happened. Tatevik Hunanian filed a trademark for the name Sister Abigail, okay? She applied for it in June of 2018 after the WWE had abandoned the application. So WWE had tried to apply for Sister Abigail, and then they just kind of let it go. Because when you apply for a trademark, once the USPTO gets back to you, you have about 6 months to respond, right? Otherwise, they considered that you had abandoned the application. So WWE let the 6 months pass and the application was abandoned, and Tatevik decided that she was going to apply for the trademark. However, WWE found out and they filed opposition 1 day before the deadline was over to file your opposition. They said that she did not create the character and that she was an extra who never played the character but wanted to. So basically she was an understudy at WWE, and they're saying that she wanted to be Sister Abigail, but she just wasn't. Tatevik, on the other hand, she said that they knew that they would oppose it, but she's still going to try and get it because she's like, well, they ain't doing nothing with it and I can do something with it. So we will see what happens because they abandoned the application, right? So there is an argument that you didn't plan to do anything with it if you filed the application and you just let it go. But anyway, we will see what happens with this WWE case. I know that I went rather quickly today. Like I said, I don't have a lot of time, but I still wanted to get you guys these stories. Remember that my Protect Your Biz webinar is on sale, $35 until 10 a.m. Eastern time tomorrow. After that, it goes up to $79. It's a 2-hour training teaching you how not to be like these people in these stories, so you don't have to change your whole business name or get sued or lose your patents or lose your trademarks. So go get it. All right. I hope you guys have a wonderful weekend. If you have any questions about the stories, please DM me. I want to talk to you guys. Also, if you have any stories that you want me to talk about, submit them. I would love to feature your stories. And I can't catch them all. I'm one person. So when you send me stories, you're helping me out. But yes, One True Empress, thank you for hanging in like a champ. You are always here. Thank you to all those who watch on the replay. And I hope you have a wonderful evening. Bye, guys.